Hello, everybody. There's quite a few documents filed today in the Andrew Colborn versus Netflix. This is document 263. Yep, 263. United States District Court for the Eastern District of Wisconsin, Milwaukee Division. Andrew Colborn versus Netflix. Defense joint and unopposed civil expedited non-dispositive motion for leave to exceed page limit for a brief. Pursuant to civil local rule, defendants hereby jointly move to court for an order to granting extra pages for their respective principal memoranda in support of their motions for summary judgment. In support of this expedited motion, defendants state as follows. Civil Local Rule 56B8 limits principal memoranda to support the summary judgment of 30 pages and requires leave of the court for more. Netflix and producer defendants each respectfully requested additional 30 pages for a total of 60 of briefing space for the principal memoranda. The request is justified for several reasons. First, plaintiff's second amendment complaint, as 28 pages long with 82 numbered paragraphs and additional 28 pages of exhibits. It puts its issue, Making a Murder, MAM, a 10-hour, 10-episode series of documents, events spanning decades. Plaintiff sues not only for defamation but also for intentional infliction of emotional distress. The SAC contains 16 different paragraphs, and the purport to set forth false and defamatory statements is also points to Exhibits A, B, SAC 59. Plaintiff alleges that the Exhibit A depicts numerous inaccuracies and facts that, in addition to the defamatory statements set forth in the SAC itself, plaintiff alleges that Exhibit B is transcripts of experts of plaintiff's trial testimony, which included the MAM, but that were significantly altered to present false impression of plaintiff's testimony. Plaintiff has resisted efforts during discovery to narrow number of statements as issue. Plaintiff throw it at the wall and see what sticks approach has resulted in scores of allegations against defendants generally and collectively, and include, among other things, challenges and numerous editing decisions, complaints about MAM's use of music, graphics, and other visual aids, and broad allegations of actual malice. Exhibits A and B alone raise undifferentiated challenges to wide swaths of documentary covering dozens of discrete statements, some of which are not even about plaintiff. Plaintiff also challenged content that is not even an MAM. Alleged admissions from the documentary had raised generalized complaints about the alleged tone of bias and the defendant's alleged profit motive. First Amendment and common law, this court must apply to deciding the defendant's motion for summary judgment as well as settle the non-particularly complex. But the plaintiff's approach to pleading requires explanation of the multiple ways that the controlling law precludes his claims, which specifies apply to each challenged statement on editing decision. Also, each challenged statement must be considered within the context of the series as a whole. Second, a Rule 12 stage, both Netflix and plaintiff requested and were granted leave to file oversized briefs. Netflix filed a 50-page brief in support of the motion to dismiss, which did not even address the actual malice. Plaintiff filed a 90-page opposition, dockets 119 and 131. Since then, the parties have developed a voluminous evidentiary record. Nearly 50,000 documents have been exchanged in discovery. 9 witnesses have been deposed, amounting to more than 54 hours of testimony, and hundreds of pages of discovery responses have been provided. The entire record of Mr. Avery's murder trial has been placed at issue, also before the court for consideration of the 10-hour documentary series itself. Meanwhile, the defendant's briefs must address all material issues, including whether the plaintiff has any evidence of malice, whether the statements and admissions plaintiff points to actionable as a matter of law, and whether plaintiff's claim, i.e.ed, may proceed. In distilling the evidence of the court, defendants must make difficult choices about what the court needs to consider, and will endeavor to describe the evidence and law succinctly, the possibility, and avoid repetition. Further, the parties are working diligently to agree on stipulations beyond admissions contained in the declaration of Andrew Colborn filed herewith. Despite the significant efforts, defendants need additional pages to adequately address the issue raised by plaintiff, expansive complaint discovery responses. Third, permitting comprehensive briefing on these topics will focus issues in the case. Defendants believe the court will be persuaded that no issue or of fact remains for trial, disposing of the case entirely. But even if a summary judgment is ultimately denied, the briefing will focus on streamline the case for the jury. Allowing oversized principal memoranda no more than 60 pages will also permit more proper preservation of issues if required later for appeal. Fourth, the motion unopposed, the plaintiff agrees that he will not prejudice. If the granted, defendants will not oppose corresponding request of plaintiffs to file equivalently oversized brief in opposition to the defendant's motion to summary judgment. Wherefore, defendants respectfully request that the court grant expedited non-dispositive motion to leave the exceeded page limit for brief and allow Netflix and producer defendants each file a summary judgment memorandum more than 60 pages. By opposing defendant's motion enlargement, plaintiff in no way admits to the substantive material contained in the motion defendant's forthcoming memoranda. Signed this date December 6, 2022. There's another document, 264, which I'll be going over next. I'm sorry if my camera's all laggy. I had a issue with my computer, and thankfully my friend let me use their laptop. So, see y'all on the next one.